Good evening, y'all. Welcome to Conversations. I am Rob Simpson, the executive producer, and we're just excited. We've had so many folks, and we're here because of you. You've heard from Tish James, the New York Attorney General. You heard from Attorney Ben Crump on one of the shows. You heard from the president of the Urban League, Mark Morial, and many others. And you wanted to create a show that addressed current issues. And that's why the Praise Party, for those who don't know, it's a nonprofit organization focused on addressing current issues in the Black and Latino communities, and also to educate and develop gospel artists. And we're excited tonight. For tonight, I will tell you, as excited as I am, I have some concerns, y'all. You know about the verdict. You know what happened. I'm going to cover with my dear guests. We have some great guests tonight. The three M's, though. It's the murder, the mission, and the meaning. The murder, we saw what happened to George Floyd. The mission, the way that AG Keith Ellison was on a mission to get a guilty verdict. And then the meaning. What is the meaning of yesterday's verdict? Does that mean that we can all just live feast? No harm, no danger. We're good. Are you comfortable? You satisfied? Do you still have to worry about whether you have to go on Facebook Live when you're stopped by a police officer? Those are some questions that our experts are going to address. What does it mean? Is there appeal? Are we really done? Or will Derek Chauvin be able to get liberty by an appeal? I don't know. Police reform. What's our 30-year plus detective going to say about whether police reform is really going to happen? We just don't know. But what we do know is that we have a star-studded group tonight. Two wonderful former assistant United States attorney. Let's show a picture of who's coming on first. Yes, it's Vanessa Singh Johannes, and she is, thanks Maurice, and she is an assistant U.S. attorney, former assistant U.S. attorney, prosecutor, federal prosecutor with a great star-studded history. And also only that, she's currently a trial lawyer with the law firm of Carlton Fields, all the way from Miami. We're not worrying about the weather down there, but come on out here. Federal prosecutor, former prosecutor. What's going on? How are you?
Hey, Rob, what's going on?
Oh, it's great to have you in the house. I am excited. And so we're going to hear more from you. But before we do that, I want to introduce our next guest. We have a longtime LAPD, Timothy T. Williams Jr., homicide expert, and he's also the author of A Deep Dive, an expert analysis into police misconduct. Let's talk about that. Come on out here, Timothy Williams Jr. What's going on? How are you?
How's it going, Robert? Thanks for having me.
Oh, listen, it is wonderful to have both of you here. And I want to remind those who are watching, and I appreciate also, I want to say thank you to the One God Network, and thanks for the Omni Channel Theater, who are also going to be streaming live. We just want to say hello to the audience for those folks. We're glad that you're interested in this verdict topic and you want to stream us live. We appreciate that. And before we get into the discussion, I think it's important for our viewers for those who might not have even seen it, what happened yesterday? Let's play that.
Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, Count 1. Court file number 27, CR 20-12646. We, the jury, in the above entitled matter as to Count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:44 p.m. Signed, juror foreperson, juror number 19. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict agreed to this 20th day of April, 2021 at 1:45 p.m. Signed by jury foreperson, juror number 19. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these are your true and correct verdicts.
So we all heard and saw the verdict. And before we get to your commentary, I just want to play one more thing that we also saw. Could we show a reaction from the crowd outside the So we saw the verdict, we saw the reaction. I do have a question for each of you. Do the mothers of those children who have black and brown skin get a chance to sleep more easily because of it? I'm gonna start with you, former Madam Prosecutor, Vanessa. What's your answer to that? As you're the mother of how many sons? I'm sorry?
2 sons and a
Two
daughter.
sons. All right, talk to me.
So I think this verdict brought all of us what we needed in the sense of relief and hope. That's what I felt when I heard it. I sighed because we were all holding our breath throughout this trial and while we were listening to that verdict be read. And then you could see from the audience the same wave of emotions. They're excited and then they feel that relief and they start crying. And then it's followed by hope, because if we didn't get this verdict, it's for many reasons, which I'm sure we'll talk about in this program, because this case was so extreme in its nature and so unique in how the prosecution presented the case. If we did not get a guilty verdict, what that would have meant. So I think hope was renewed, which was needed across our country as a whole. Doesn't matter what race you are, doesn't matter what you believe, we needed that hope. But as a mother, what I can say is I think this gives us a glimpse of what the criminal justice system can do. But this is not the end all be all by any stretch of the imagination. As a mother, yes, I have 2 sons, Rob. They're young, but I also have nephews. And every single one of them, my sons, my nephews, they're brown and they're black. And my nephews, especially the ones that are teenagers, I worry all the time about their interaction with law enforcement. And I was a former prosecutor, and I have a lot of friends who are in law enforcement. I have a tremendous amount of respect for law enforcement. They serve a unique and necessary purpose. But I don't think yesterday's verdict cures the conversation, the talk that mothers and fathers across this country have with their children. It does not cure the conversation that parents have with their children about how to act when they get stopped by police, put your hands on the wheel, how to talk to police, how to de-escalate a situation, because we know that this case is so rare. That's why this case is not the pattern of convictions that we see. And there's reasons for that. And we can go into that in this program. I hope we do. But this is a one-off that we needed and we desperately hoped for. And I'm glad the jury delivered on that. I don't think this solves the problem in any way with the disconnect between law enforcement and the community that we're seeing across the country.
That was a perfect segue. We talked about law enforcement. Speaking of law enforcement, our senior former LAPD detective, author of Deep Dive and looking at police misconduct. So what's your thoughts there, Timothy Williams, and with respect to whether this brings any type of a sense of relief or calm for those mothers who see their children, their Black and brown children, going out into the world every day?
Well, Robert, I will give you a perspective from about 30 years in active law enforcement and the last 18 years of dealing with police procedure, use of force, and wrongful conviction issues. And I look at this verdict, and I have to echo what State Attorney General Keith Ellison stated. This is not justice. What we saw was accountability. And I agree with that. There is a lot of things that have to come into play for in the criminal justice system. I have 3 sons, and I worry about them every day. I worry about them when I was in law enforcement. I worried about them, because I've had to have to talk with them. I have 6 male grandchildren. I worry about them every day. Their fathers have had to talk with them about interaction and dealing with law enforcement. So there is a concern that I have. The verdict does not change or impact upon the systemic issues that are in law enforcement. More specifically, I will say the criminal justice system. I was just on a talk a few days ago, and where a sitting judge was in the audience, and we talked, said the reform has to go beyond the issues of law enforcement, but it has to deal with the criminal justice system, the parole, probation, even the bench, the child and family services, and the like. So we have to look at it as a whole. As I watch the political climate in this country, I do not see an appetite for a change in this system. We have the George Floyd Criminal Justice Act that's in Senate as we speak. I don't see an appetite to move that bill to the president's desk, and that's really a very sad byline. In that we should want to change the systems in the criminal justice system, the systemic issues that need to be changed in this country. But I don't see that desire coming forth.
What does this mean? Vanessa, you are a former prosecutor. What does it mean for change in our country? What does it mean for future cases that will be brought against law enforcement? Is it more of the same, or is this just one-off and we get elated for our one and done victory? What does it mean to you?
Well, look, police reform and criminal justice reform, I wouldn't think of it necessarily as police reform. I think you're right, Timothy. We have to think about this as a whole, as criminal justice reform, starting with even beyond, being in the criminal justice system and re-entry back into society. You have to think about it from the phase of education, our education system, and what's feeding juvenile crimes and what's feeding the system that leads to incarceration. So I think the problem, you have to think about it holistically. But with respect to this case, and is this case going to pivot change with, dealing with prosecutions? I think you have to understand that the criminal justice system and the prosecutors and the courts don't operate in a silo. And sometimes when we see police-involved shooting cases come forth, when we see prosecutions come forth, everyone is very quick to blame the prosecution. Everyone's quick to blame the judge. Everyone's quick to blame the jurors when the results are not necessarily what we think is fair, we don't think is a just outcome. But the judge and the prosecutors are operating in a system in which they're confined. They're operating under the laws as they are written. Those laws are not written by the judge. Those laws are not written by the prosecutors. They're written by elected officials. And I always tell people, if you really, really, really want to change how the criminal justice system operates, you have to change the laws and the rules by which we are operating under. Vote, elect officials that you are going to hold accountable if they do not bring meaningful change to the platform. There is a reason why Derek Chauvin's defense attorney reiterated, and it was his theme throughout the entire trial and throughout his closing, he continuously reiterated Derek Chauvin operated as a reasonable officer would in his shoes. Because it's very clear, and the case law is clear across the country. If a reasonable officer believed he was threatened, if a reasonable officer would have used the amount of force that Derek Chauvin would have, you can't find him guilty. That's very, very hard for the prosecution to prove a case. In this instance, we have a video that's showing an excessive use of force over 9 minutes long. We're literally watching someone die, someone being murdered. But in most cases, you have split-second decisions by law enforcement. We've all seen the videos. We've all watched it. The videos show the taser being confused with the gun. The videos show someone running. There's a shot. The videos are very quick. And when you have very quick snapshot decisions, and Timothy can elaborate more on this as being a detective himself, it's hard to show that a reasonable officer in that situation would not have acted the way the officer at hand did. So do I think we will get a line of convictions here on out, similar to what we saw in the Chauvin case? I certainly hope not, because that means we have cases as egregious as what we just saw, and we have more people dying in a manner as we just saw. But do I think that there needs to be some reform of the laws which allow such a large latitude for law enforcement to act and to have such large discretion in their actions? Of course I do. But I don't think that's one and done. I think police reform is not just one law, one training, one policy. You've got to change a lot in the system. It's a lot of pieces at play.
So Timothy, talk to me about police misconduct and police conduct as it relates to any impact from yesterday's decision. So you've been in law enforcement for over 30 years, detective with the LAPD. You now sit on the side of investigating homicides and looking at these for a living. Is this going to change the way police conduct themselves? Really?
I don't think so. There is, you make complaints. If citizens make complaints, and they get documented, and they get a letter back saying we investigated your case and we found no misconduct, and that's the normal focus on police misconduct. I get calls from all across the country. And some of the calls will bring tears to your eyes of, if these stories are in fact true, of the police misconduct that goes on from California to the New England states. So the thing is that, I only change that I see being made is a systemic change. You got to bring the right people into the system. You got to bring the right people with the core values that are needed to be in the system. You got to look at the training. The training, I remember when I first came on the job, I spent 4 months in the police academy, and my training officer told me, he says, Williams, forget about everything that you learn in the academy. This is how we do it in the street. And that's the mentality that not is only in California, in Los Angeles, but all across the country. You see that when they leave the training field, or when they leave their continuing education, they check the box, signed off on the roster, and just leave what they've learned where they learned it at, and his business as usual. So the thing is that, again, it goes to accountability. The organization, the law enforcement organizations have to hold the subordinates accountable. They have to hold supervisors accountable. They have to hold upper management accountable, and they have to hold chiefs accountable. I do a lot of civil rights work, and especially when it comes to these police shootings, and I can almost tell you what the testimony is going to be, because it's uniform all across the country. It's I feared for my life. The same. I told them to stop resisting. You see. So the thing is that you've got to break the culture. You got to break the culture.
Well, talking about breaking the culture, we had a win yesterday, and I say we. Yes, we had a win. Justice is not served, because we know that it's not. There are a lot of issues, but accountability. I like when you said that, Timothy. Yesterday was accountability. An officer that murdered someone was accountable for his actions. But in terms of a change in landscape, let's play a clip from the very end of the closing argument. If you could run the tape, please.
So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win. I'm not trying to win. Go get in the car then. I'm on the ground. Anything. Go get in the car. It's a ball. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please? So you get in the car. We can talk. I am claustrophobic. I'm claustrophobic, man. You're working with me. God, I'm claustrophobic right now, man. Can I get in the car? Get me in the front? Please. No, you're not going to get in the front. I'm claustrophobic, Mr. Officer. Get in the car. Okay. I'm not a bad guy, man. Get in the car. I'm not a bad guy. You haven't win. Oh, man. Oh, please, Officer. Please. Please, man. Please. Hold on, no. You take the seat.
We can pause it there.
I can't breathe.
I was concerned, Vanessa, that as Timothy was said, you know what the outcome is like. Resisting arrest. You know, here it is. You saw 3 officers trying to get this man in the trunk into the back of the car. What happened? Why is it that this particular narrative didn't work this time?
I think there are 2 things at play. One is this was not a split-second case. This was a case that dragged on. This was a case where Derek Chauvin had his foot on Mr. Floyd's neck for over 9 minutes. This was a case
9:29, 9 minutes,
9:29.
29 seconds. Don't forget those numbers.
We thought it was 8:46 last year. Now we know it's 9:29, 9:29. But 9 minutes and 29 seconds is a really long time. And in most police-involved shootings, and Timothy can speak further about what he has seen, clearly what I have seen is it's under 10 seconds, under 5 seconds. It's very quick. And so here, had Mr. Floyd continued to resist, and the ending, which we know happened, his murder, his death happened, quickly within that time period, I'm not sure you would have had the same result. I'm sure the defense would have said, look, he was resisting us the entire time. We feared for our lives. He's big. He's a big guy. We were scared. But here you had him, first of all, handcuffed on the floor, and then he was there for 9 minutes and 29 seconds. At some point, clearly to anybody, to any human being, that became excessive. The second thing is, because I said there were 2 distinctions here, I really think, for the state and why they had such a strong case. First, the timing, and second, you had multiple officers, you had the chief of police testify for the state. That's rare. That's really rare. That officers testify that this specific example, what I'm seeing, if I put myself in this officer's shoes, my brother's shoes, because they are a brotherhood, they're together in this, they're a family. And if I put myself in his shoes, I would not have done this. In no circumstances would I have done this. That's rare that we saw that kind of testimony. And I really think for the state, that made all the difference. In split-second cases, which, like I said, we're too used to seeing those videos, I don't know how many officers you'd get saying, I wouldn't have made the same decision. I wouldn't have been in fear for my life. I think here, that was the biggest distinction.
So Timothy, hold on a second. I want to know, 30 years on the force, you've dealt with them, you've been in the trenches with those officers, you've trained them. What happened here that the chief of police decided to break ranks from the brotherhood? Breaking ranks from the brotherhood. That's what Vanessa said. What happened here?
What happened was it was so egregious that that the chief came out, and this is something that you don't see. The chief came out in front of God and everybody and said, this is wrong. You see chiefs testify from time to time in the civil rights side of the arena, but you very rarely, you don't see them testify in criminal matters. And what this chief did, he changed the paradigm, if you will, in the country as it relates to chiefs of police. the chiefs of police have to, they have to come out from behind the desk. They have to quit giving their press releases, platitudes, and be leaders. What you saw was an example of what a leader should do and what he did. Now, then you had 4 other subordinate supervisors come and say the same thing.
That's a rarity. That's a rarity.
You don't see that. It was out of policy. You heard of the thin blue line? Well, for this particular case, that clear blue line was destroyed, and they crossed it, and there was no code of silence at that level, at the supervisor level, as what we saw in this trial.
Vanessa, I want to get your thoughts about the prosecution and just a couple of things. My dear friend and brother in the practice, Jerry Blackwell, did the rebuttal. And could you just play that last piece that he had?
You were told, for example, that Mr. Floyd died. That Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
I want to know, here it is, Keith Ellison made a decision. He's going to bring 2 lawyers out of private practice to go ahead and prosecute the case. Is that the model, Vanessa, or are some attorney generals going to say, we're just going to kind of keep it in-house? Can you give me some perspective there?
Well, I can tell you from the federal perspective, because that's where I practiced. In the federal system, this case would have been handled by DOJ and the U.S. Attorney's Office in which the case was brought. I think the decision here was made to bring in attorneys from the private sector because, A, the weight of the case was extremely heavy. We all knew that it was going to get a lot of media coverage. It did. We knew the significance of it. Surely the Attorney General's office also knew the significance of it, and they couldn't take any chances. Not to say that their own prosecutors would have been taking a chance on the case, but I think they needed every hand that they could get. I think they needed to look somewhat impartial, if you will, in terms of bringing the charges and having their office handle the matter in their own backyard. Also bringing in lawyers that are not prosecuting on a regular basis in their own backyard. I think it was a strategic choice. It was a good choice. And I will say something about the words that the defense attorney said at the end, which you just played. It's hard as a prosecutor not to involve yourself emotionally in a case. Cases are not emotional. Cases are built on facts, and there's a reason for that. Having tried many cases, I will tell you, a jury tries, they really try hard to get it right. And they try not to operate on emotion, not because they feel like it's a good thing, but because they're instructed not to. We don't want juries coming to conclusions about guilt or innocence based on their own personal beliefs. We don't want bias in the system. We want them relying on the evidence beforehand. But I do think the choice of words that the prosecutor had at the end, that the attorney had at the end, about Mr. Chauvin had too little of a heart was great. There's a time and a place you can bring emotion in, and I thought that was a perfect timing to do it.
I'm wondering, Vanessa, is it something where prosecutors, maybe they just need to improve their playbook? Maybe it's the fact that the defense attorneys, they go ahead and they appeal to the passion of the jury, the reasonable doubt. You're going to put this man in jail, and the prosecutors, as you just said, toe the line, cross the T's, dot the I's. Maybe they need to have a little bigger heart in terms of taking more chances. What are your thoughts about that?
I disagree. I think that the prosecutors bring forth the cases that they think are going to be successful. Should they bring forth all cases? No. And the reason for that is because they will lose them. And the ramifications of losing them and setting poor precedent is dangerous practice. Look, there's a lot of police-involved shooting cases. I mean, if I give you the statistics, they're really dismal. The Washington Post has been compiling statistics, I think, since 2015. And since 2015, there have been over 5,000 police-involved shootings that result in fatalities. But yet, since 2005, there have only been 7 police officers, 7 since 2005, that have been convicted of murder or manslaughter. The numbers are poor. Yes, the charges, there have only been 140 charged since 2005. Clearly, prosecutors aren't charging the case. But as I said earlier, they're not charging the cases not because they're shy of going in a courtroom. Prosecutors are anything but shy of going in a courtroom. They're not bringing forth
you're
the
not.
cases. No, I mean, look, and they're not. If the facts and evidence are there, they're going to bring the case. But the reality is, and I can't stress this enough, the law is not written in a way that's favorable to convict law enforcement. And Timothy knows this. It's just not written that way. It's written on the side of getting the acquittal for law enforcement. So you run the risk as a prosecutor bringing forth a case you know you're going to lose. And I can tell you, at the federal level, you're not allowed to do that. You're not allowed to bring forth a case that you know you're going to lose just to appease the public. If the evidence is not there, you don't bring forth the case. And that's the way it should be. Now, if we want to change that narrative and want to change that discussion, everybody should call their senator. Everybody should call their representative and advocate for criminal justice reform. That's the only way that piece of the puzzle is going to get fixed.
So, Timothy, with respect to how the case was tried on behalf of the defense, they're showing the resistance that obviously all of the fentanyl and the other drugs that they try to make an issue of it. Is there anything that you thought that the defense did particularly well?
Well, I can tell you what they did wrong.
Okay, you can do that.
Yeah, I think one of the things that hurt the credibility of the defense was bringing on the police procedures expert that they used, because what you saw there was a mentality that begs for reform, and anytime someone gets up there and says, based upon what the world has seen, that Chauvin did nothing wrong, what he did was correct. Well, what you paid for was that testimony. You see, and it makes experts, that are, it puts a taint on experts as a whole, because the thing is that when I testify, they always ask, well, what do you, what did the council pay you? Well, they paid me for my time. They didn't pay me for my testimony. And you've got to be willing as an expert. And I've told many counsel, and then they had to spend money for me to get to that point. I can't help you. I just can't help you. At the end of the day, you have your credibility. It's all you got.
Right. That's right.
See, and if you go in there and testify the way that we saw, well, then your credibility is shot. The other thing is that their job, the defense job, as Vanessa will tell you, his goal. He told you in the opening argument. He says his thing was 2 things: common sense and reasonable doubt. That's simple. He was playing on their common sense and trying to bring up a reasonable doubt. All he had to win was one person, and we would be having a different conversation this evening. So the thing is that, as a defense attorney, you don't get a chance to figure out the facts of the case. You got the case. The case is what you got, and you got to do the best you can with what you got. And try to make it work, and it didn't work.
We're gonna come back in a moment. Folks can please feel free to chat your questions in the chat. We'll recognize that and we'll post them accordingly. But before we come back to this, because I want to talk a little bit about the appeal, I just wanted to, if you can bring up the conversations, our next show, please. Yes, Friday, May 7th. Friday night. This is a special edition because we wanted to hit the verdict. We have 2 young women from the U.S. Olympic team, Paralympics, that have some powerful stories, and you don't want to miss this. Sydney Satchel and Nikki Nieves. You want to make sure that you're there for that. That's Friday, May 7th. Conversations, and of course, as you know, this is Praise Party, and we have our next show that's coming up on May 21st. More Than Her Praise, a special women's edition. It's just going to be an awesome time. That's Friday, May 21st, 9:00. And before we go any further, let's play the piece from Maxine Waters, because I want to come back and get some views from, in particular, our federal prosecutor, our trial attorney, and get to see what Vanessa says about this appeal. Can you play the piece?
What should protesters do? Well, we got to stay on the street, and we've got to get more active. We've got to get more confrontational. We've got to make sure that they know that we mean business.
You know, we've got to get more confrontational. You know, that was taken all through the mud, through the, you know, it was just ugly what they were trying to do with that statement. The question I have, Vanessa, is are you concerned? Are you concerned that statements like that, even the judge gave it credibility? He said, you know, that even though he didn't declare a mistrial, he said, look, that's something I'm concerned that may result in an appeal. You have given them an appealable issue. Can you address what you think about the appellate chances by our dear defense?
Sure. Well, look, first of all, it's not a question of if Chauvin's going to appeal. Of course he's going to appeal. I mean, that's standard practice in a case like this. And his lawyer has clearly set up his arguments in court. With respect to the basis of appeal, I think that he'll appeal based on a couple of things, one of which is the denial of the change of venue. I think he's going to lose on that. You know, no matter where you chose as venue for this case, everybody in the country knew about the George Floyd murder. So I don't think that changing the venue would have made any difference. Sure, you know, he will argue that operating on home turf clearly didn't help, but I don't think he'll succeed in that regard. The other big avenue that he's going to pursue on appeal, which he has set up, and he set up by bringing up the Maxine Waters statement, is whether or not the jury was fair and impartial. Now, the question of whether or not the jury was fair and impartial comes down to a couple of factors. One, here, what was voir dire like? We know that voir dire was extensive in this case. The defense attorney, Mr. Nelson, was given adequate time to question the juries, and he did question them. Not only did he question them at the outset of the case, but when the civil settlement occurred, he was permitted time to question them again and to inquire again about the impact of the civil settlement. And a couple of jurors were actually let go at that point, who responded that, yes, the civil settlement tainted their view of what would occur in the criminal case and how they would view the criminal case. So the question is going to come down to this jury that we had here sitting, that were in panel, these 12 people. Were they fair? Were they impartial? Did they base their decision on the evidence brought before them? And beforehand, when I was talking about the reason prosecutors stem away from emotions is exactly the reason what we're talking about here. They steer away from emotions because they don't want to lose the case on appeal. You do not want a verdict coming out that's purely emotionally driven, that has no basis in the facts, no basis in the evidence. Why? Because the argument is going to be that your jury made that decision, not based on the facts, not based on the jury, not based on the evidence brought before them, but based on their biases. Now, here, it is an uphill battle on appeal because the evidence in the case was so significant. I mean, it was so clear cut. Everybody who watched the trial watched the same thing we watched, right? The prosecution clearly, to me, met their burden beyond a reasonable doubt, and anything the jury may have seen beforehand, doesn't. And I'm balancing the evidence. The evidence clearly holds the upper hand, but the judge also every day instructed the jury, as most judges do in every case, every criminal case, do not Google this case. Do not watch TV reportings on this case. Do not go on social media and do anything about this case. All you can do is have the code of honesty and hope that the jurors are not doing that. In this case, there's no indication the jurors were doing that.
Right.
They weren't sequestered until the very end, but I don't see that as a problem. There's no indication anybody was on social media or doing anything abnormal. I will say there is a pending case before the Supreme Court, which all of us are going to be familiar with the case, the Boston Marathon bomber,
Right.
Which was equally a notorious case where the same arguments were raised by the defense. The case shouldn't be tried in Massachusetts. It should be changed venue. That was a federal case that was brought. It was a federal prosecution, not a state prosecution, but it is on review. And the Supreme Court has agreed to hear the case this fall. And the issue that the Supreme Court's looking at is this, and it relates to exactly what we're talking about. The district court obviously, inquired of the jury of their biases, but the appellate court, the First Circuit Court of Appeals, held that the self-declarations of impartiality by the jury are insufficient. There should have been more press of them, of exactly what they were watching, their news outlets, not just, I declare myself impartial. There should have been more pressing of it. Now, that being said, that the Supreme Court's looking at it, you have to understand the Supreme Court's looking at it as to whether or not the sentence should be upheld and he should be resentenced, not whether or not the overall verdict should be overturned, because this is a federal case and it's not apples to apples, it's apples to oranges. Here we have a different case, we have a different system in which we're operating. I just raised that because that's clearly, I think, what the judge was referring to when he talked about, Maxine Waters causing like an appellate issue. Because this case is pending before the Supreme Court. And who knows what the Supreme Court's going to say about self-declarations of impartiality holding up in criminal cases.
So I want to, so Vanessa, the bottom line is uphill battle for the defense on appeal, not really seeing any grounds from what you've seen. And we can rest comfortably that this verdict is going to hold.
I think we can rest comfortably with this verdict.
Okay.
He's going to be sentenced in 8 weeks, and I think we can rest comfortably.
All right, everyone heard that from Vanessa? Johannes, she's telling you right now, rest comfortably tonight. The verdict will hold. So I want to go to one of our viewers had posted we'll bring it up on the screen. The question is, why aren't the police using de-escalation in these cases before shooting? We're obviously moving to a different type of case. We're not talking about Floyd, but the question is, what about de-escalation? Like, what is the issue? I mean, we time and time again, Timothy, we see your former men in blue that they just would seem to me, like I'm not in law enforcement, it seemed to me that they would de-escalate as opposed to pulling the trigger or pretending that I'm sorry, did I say pretend? It was a taser versus like I'm stuttered. I just said pretend, but I know it's legitimate. That's legit. It happens. I know. I don't. So I just want to say, what's the deal? Is it, why don't they de-escalate more?
Well, let's stay with the George Floyd case. Okay. My analysis, I broke down the case down into 3 acts. What you showed was the second act, and there's a lot of movement going on in the second act. That was a prime example of what should have been done to de-escalate that situation. Here was a man that was over 6 foot tall. He was a stout man. And I don't know if you've ever been in the back of a police car. It's a very tight fit. I'm short. I'm 5'9", and it's a tight fit for me sitting in that car. And it's not going to work. What they should have done was, look, hey, I understand. We will get another mode of transportation, and get you to the station so we can finish talking about this. That's a form of de-escalation. They didn't have to go in there and try to drag him across the seat to the other side.
I'm going to have to pause you right there, because the way you describe it, I think that's like pretend police. Right? No, because this whole thing, this is like, okay, hold on a second. Let's get another car so we can go ahead and put you back because there's not enough room in here. Does that really happen?
Let me tell you, Robert, I'm not an academic. I'm a practitioner. I've done this for almost 3 decades.
Yes.
And you should have to fight everybody to jail. And number one. Number two, this wasn't an arrestable offense to begin with anyways, Act 1. So the thing is that you have to know how to de-escalate. Everything is not a fight. It's not a tussle. And you sit down and tell them, says, look, we're gonna get you another unit here. We get you in a car that'll fit, and we will make sure that that the windows in the front are rolled down so that you can be comfortable, turn the air conditioner on, and get you to the station. Number one. Number two, they should have had a supervisor out there immediately. They should have had a supervisor out there because it was going north very quick, and they didn't do that. In fact, the supervisor was in communications, and the communications operator had to bring it to his attention as to what was going on out there. So the thing is that, and the defense should have hung their hat on that. They didn't do it. But the thing is that, you have to de-escalate. You train in de-escalation, and you have to de-escalate. Everything is not a fight.
Vanessa, before coming on the show, you shared with me that this case was, the evidence was just overwhelming. Like, it was overwhelming. Like, you would have been shocked that the jury would have done anything other than find him guilty based upon the evidence, right?
Yes.
But the problem is there's so many instances where the evidence, at least from somebody who sits in the cheap seats like me, seems to be just overwhelming, but yet the verdict's not guilty. Can you kind of reconcile that for us a little bit as we start to wrap up here in the next 5 minutes? This is the bonus round. So we're going to wrap up and I'll ask for commentary. But what's happening? Because that's the challenge that a lot of us have. Like, why is this case different?
I mean, that's a challenge I have in so many of these cases, but I know the law in a way that, you know, the average person does not. I know that it's hard to secure prosecutions to even bring forth charges when you have a situation where the officer says, as Timothy said multiple times, they're going to say, I fear for my life. He was resisting, you know, that it's hard to fight an officer's statement to that regard when there's nothing objective on the other side showing that that's not the case and that's not the situation. Unfortunately, the police involved shootings usually involve very fast-paced scenes, not drawn out the way that we saw with George Floyd. And because they're so fast-paced, it gives the officer that cushion, if you will, to legitimately make those arguments and to secure an acquittal. Now, I'm not saying it's right. I'm saying that that's just the way the law is structured right now. And you have to understand that it's not the prosecutor's fault that the conviction is not secured. And frankly, it's not the jurors' faults necessarily. The jurors are actually trying to follow the law given to them. Take, for example, the case of Trayvon Martin. I live in Florida. I watched that keenly as it was taking place. I've met his mother. Everybody was wondering how on earth that verdict could have been not guilty. How? And, you know, the case was so well presented. Well, Florida has a standard ground law, and it's pretty ironclad. And most states have a very ironclad standard ground law. And it doesn't give much wiggle room for a guilty verdict, unfortunately.
You're not making me feel too good, Vanessa.
No, you know what, though? I do want to end.
Feel too good, Vanessa.
Well, you asked me, Robert.
I
know.
Listen, I appreciate we have you here because I think it's important for the viewers to understand that. I mean, that you're speaking about the laws that are in place, and that's why you said early on, I think at the outset of the show, that look, everybody here has a responsibility to elect the right people. We're going to have the impact in the legislation who are going to put these laws in the books. And if the laws aren't fair, aren't just, do something about it. Because otherwise, you know, we're going to be back with the same situation, which you said, you know, Trayvon.
Can I say something about elections mattering?
Yes.
Today, DOJ announced, the Attorney General announced that they're going to investigate the Minneapolis Police Department.
Yes.
That may not have made, you know, wide news for a lot of people, but that's a pretty big deal. I was in the Civil Rights Division in our office, our U.S. Attorney's office here in Miami for a little bit, and I can tell you that has weight, that has volume, that has the ability to bring about change. Why? Timothy talked about de-escalation. He talked about how do we change police practices? How do we change their training? What DOJ is going to do is, this investigation is not criminal, first of all. People have to understand that.
I want to pause it here. I just want to make sure everybody is following. So the Department of Justice, what is it, yesterday? Today announced what?
The Department of Justice announced that they are going to look from not a criminal standpoint, a civil rights standpoint. They're going to look at the policies, the procedures, essentially the culture, okay, if you will, of the Minneapolis Police Department. And what they do when they do that is they take a holistic approach. They look at all their practices, their de-escalation, their policies, what's happening on the ground, and then they come up with a report. And that report says, these are the things we think you're doing wrong. These are the problems we see with the police department, and these are the solutions we propose. Now, the Minneapolis Police Department does not have to agree to the solutions, but the goal for DOJ is to get them to agree to a consent decree. And what that is, it's a fancy term, but all that is it allows the court and Department of Justice to monitor the policies, the procedures, the training that's taking place in the Minneapolis Police Department and help to change it over time. Because the prosecution of George Floyd, this verdict is one. It's one. What the goal?
Vanessa, why doesn't that happen all the time? Why doesn't the DOJ come in?
Because
Why?
Who was your past president?
Oh, jeez.
I hate to tell you, but elections matter, Rob. And DOJ is, it shifts. It shouldn't shift, but it does. And, the Biden administration has done a clear win here. Under the Trump administration, consent decrees were not enforced. Consent decrees were not sought. Police departments were not. They were not. It was the policy of the department. They were not going to do that. Biden has changed that. He's gone back to the Obama policy. And that is a good change. Hopefully more police departments, not just police departments, but state-run jails are going to be looked at for their policies and procedures, and change will come. That is how we effectuate change. But again, people got to vote.
Yeah. And just to add on that, Robert.
Absolutely. Please do.
These consent decrees are not reforms. These are changes in conduct. That's what they look at. And a federal judge will oversee this consent decree. When it gets to that, it doesn't take the place of reform. Not at all. There's two different discussions.
All right. So what I want to do, there is a question that was asked. I'll just post it up on the screen. Can the family file for punitive damages? And I just wanted to make sure that I'm gonna throw that up to the lawyer to answer that question about punitive damages, given what's going on. Is that something that's available to them?
No, this was a criminal case. And so because it's a criminal case, the result is here. It's a guilty verdict. In criminal cases, there are no punitive damages. That's a civil concept. And the family has already settled the case civilly, and they've received damages civilly. So no, that's not going to be sought here. There's no mechanism for it.
So what I want to do is just give you each a minute, whatever is on your mind by way of thoughts that you want to leave with everyone. I'd love to hear your final wrap up. So let's start with you, Timothy, and then we'll end with the rose among the thorns here, and that's Vanessa. Go right ahead.
Well, there was a couple of things I looked at as I was watching the trial from time to time, because I still have a business to run. I was watching the attorneys, and Vanessa and I were talking about this beforehand, and there was a different approach that I have seen from a government attorney. And so I researched these guys, and come to find out that these were private attorneys. Now, what Keith Ellison has done, he has made a major paradigm shift as relates to these type of high-profile criminal cases. And Vanessa could perhaps weigh in on this. As I see it, I think this is going to be replicated across the country when it comes to, especially in the area of trying police officers for murder or these type of cases. I can see it being taken to the private sector to have attorneys come in, which I thought was a magnificent move, because you saw a different type of lawyering going on, especially when it comes to the medical stuff, because it was like they were in their own swimming pool. It wasn't static. It was a smooth swim. The second thing is that I have put together a team, and we're gonna do an autopsy on this case, on this trial. And as magnificent as the prosecution has done, there is also some learning things that can be got from that. Some things that perhaps we can, you can look at to improve. Always trying to do things to improve. And as I wanted to say in one of my previous interviews, is that this case, I believe, will be taught in law schools. The closing and opening arguments will be taught in law schools, because it was so rich as a non-lawyer. I mean, I've been in the courtroom almost 47 years, so I kind of know the nuances. It was rich. It was rich, and it's some of the riches you don't see very often. And it was good. I think it'd be good for the young attorneys on both sides of the table to look at and study. But that's where I'm at. And again, finally, the whole issue of the situation, I broke it down in 3 areas. If we had more time, I would explain it to you. But in my opinion, this didn't have to have the outcome it did.
Right. Vanessa, before we wrap up, final word, what say you? What do you want to leave our viewers with from your perspective as a former federal prosecutor? And Timothy, I appreciate that MSNBC has allowed you to steal some time for us today. Thank you. Go ahead.
So Rob, first of all, I'll answer Timothy's question, or not question, but really statement about bringing in private attorneys. I don't like to Monday morning quarterback other attorneys because I would not like it done to me. But what I can say is, look, a defense attorney thinks differently than a prosecutor. It's just the way it is. Your whole stance is different. Now that I am on the defense side, I'm no longer a prosecutor. I can tell you there's a paradigm shift, and that's sometimes a good thing. Now, if I was to go back being a prosecutor, having that mindset would shift how I prosecute cases in a positive way. And so I think the defense attorneys do bring that when they shift their roles in the courtroom. The note that I want to leave on is exactly what your show is called. It's called Conversations. And, you know, when throughout the whole time this trial has been going on, and even before that, last summer I was still a prosecutor, and some of my closest and dearest friends are in law enforcement, and they're agents. They work for federal agencies or they're local law enforcement. And I talk to them all the time about this case and other cases like it. And what I will say is, one thing that I do hope comes out of this case is, you know, we had tons of cops. We had the chief of police come out and speak and be vocal. We need to have more conversations bridged between law enforcement, the community, former prosecutors, defense attorneys, because we all have different views of the system. We all operate in the system. The system is only going to get reformed or changed if you have police at the table. You're not going to reform the system without them at the table. And it's important to have that perspective because they do serve a great need in our community. So what I want to say is, even though we all have our own personal and different views, we all agree clearly this case had the right outcome, and there should be more prosecutions like it, and there should be more guilty verdicts, and there needs to be some sort of systemic change. I want to encourage people, and take all the emotion you have, take the hatred you have on either side, right? Either side has so much hate right now, and find a way to bring it together. Because if you ever want change to happen in this country, you have to talk to the other person. You have to figure out a way. It's hard. It's really hard. I will tell you, some of the things that come out of my friends that are law enforcement, they would never say publicly, but will say to me, because we're in a circle of trust, shocks me. But you know what? I'm glad that they can say it, because you have to be able to say it to have the conversation. So I'm glad to have been on your show and had a conversation, but I think more needs to happen.
Great. And when you say there's hate on other side, I also want to share, actually, I received a message when we were advertising for the show from a gentleman who said, obviously there was some hate that said to me that I have a tree that is ready for you. And I just like to tell that gentleman out there that I still love him. I have no hatred for him. I know everybody has different views of how the outcome is, and that's always going to be the case. But here on Conversations, as Vanessa said, we bring truth to the table. Thank you. We look forward to seeing you on May 7th for our next show. Friday, May 7th, Conversations. 2 members from the U.S. Olympics team. Totally different view, totally different change. We're going to change it up. It's going to be uplifting, exciting, wonderful stories. Let's play it out there, Maurice, with our outro. Appreciate you.
Thank you.
Thank you, Vanessa.
Bye.
Thank you, Timothy.
Thank
Appreciate
you.
it.
Thank you for having me.